Alright, this is going to be Legal Issues for EMS Educators, Part 2. And the topics in Part 2 are going to be Public Health and Safety Laws, Federal Health and Safety Laws and Affirmative Duties, State Public Health, Safety, and Education Codes, State Immunity Laws, Program Clinical Affiliation Agreements, Curriculum Issues, Student Issues, Grievance Policies, and Safe Learning Environment Laws. So, public health and safety laws. The federal and state workplace and environmental regulations require EMS educators to assess and improve the adequacy of equipment and clinical education provided to students who work with organic hazardous materials such as bodily fluids and tissues, as well as understand how to respond to situations involving chemical hazardous waste. Items would be hazardous material policies are essential if they come into contact with bloodborne pathogens or whatnot, a waivered agreement, recognizing that they actually have come in or will come into contact with bloodborne pathogens in their clinical environment. Federal health and safety laws and affirmative duties, and there's two things we're going to talk about in this section: Occupational Safety and Health Act of 1970 and Emergency Planning and the Right to Know Act of 1986. On both federal and state levels, environmental laws are increasingly being used in combination with workplace safety regulations whenever death and serious injury occurs due to inadequate safety equipment or protocols. So be aware that your policy and procedures kind of cover this area. The Occupational Safety and Health Act of 1970, or OSHA, Congress enacted federal OSHA legislation upon a finding that personal injuries and illness arise out of work situation impose a substantial burden on the economy in the following terms. And these following terms are disability compensation payments, lost productions, medical expenses, and wage loss. And for the last 4 decades, OSHA has been doing the following: encouraging employees and employers to reduce the number of safety and health hazards in the workplace, ensuring that employers and employees share in this responsibility, establishing and enforcing occupational health and safety standards, encouraging labor and management to jointly reduce employee injury and disease. Emergency Planning and the Right to Know Act of 1986. The Emergency Planning and Right to Know Act gives employees and their members of the community the right to better understand the risks that are posed by chemicals, toxins present in a given workplace. And from this act, we kind of find them now, which are MSDS sheets, or material safety data sheets, that are all the hazardous chemicals that are in our work environment. We're supposed to either have available knowledge through an online number or an online database, or very simply have the actual chemicals listed in a book to where we have access to them. And again, right to know. State Public Health, Safety, and Education Codes and EMS Standards of Education. Each state has a lead agency that has an overall responsibility for public sector occupational safety and health. And in this, we find the EMS Standards of Education. Now, our states run a little differently, or they actually have a state agency, and the state agency responsible for addressing EMS-related oversight is the Oklahoma State Department of Health. States vary. Some states assign the fire marshal to this appointment. The Oklahoma State Department of Health is an important source of regulatory and administrative rules, and they have all of the rules that are legislated in that govern how we would generate EMS education. State immunity laws. In order to encourage EMS educators and students to participate in educational and clinical education, most states have enacted a broad general immunity law for EMS educators. This generally does not cover any gross negligence or willful conduct. So if you did it on purpose or had a gross negligence about you, this law will not cover you. Program Clinical Affiliation Agreements. Emergency protocols and procedures are what we're going to talk about, and a framework for clinical education agreements. Educational institutions should have agreements with all your clinical sites that are involved in your clinical educational activities. A standard affiliation agreement should be clearly written and approved by legal counsel. So, emergency protocols and procedures, let's talk about this first. Affiliation agreements establish guidelines that are acceptable to both educational institutions and clinical sites. Well-written agreements identify obligations required by educational institutions, by students, and by the clinical sites. Addressing this in agreements before the students are assigned to the clinical site is helpful. And also in establishing that, emergency contact numbers, or what to do in case of an emergency, things like that. Emergency protocols and procedures are essential. The actual framework for the clinical education agreement is as follows. To minimize litigation, potential affiliation agreements should contain the following: an introductory clause, dates, performance objectives, student-employee relations, liability expectations, mutual obligations, key contact information, and then signatures. Introductory clause needs to be clearly identify all the parties involved, the dates starting and the termination dates of the contract, performance objectives, knowledge, skills, and judgment in this as far as the performance objectives. Affiliation agreements should provide measurable student achievement-based objectives, student-employee relationships. You should clearly define what the student and the employee relationship should be. Mutual obligations, generally this part addresses any obligations of the educational institution to the student and to cooperating clinical sites, as well as obligation of the clinical sites to the students and to the educational institution. Key contacts are going to be names, title, mailing addresses, informal notification, and contact numbers for both the educational institution and the clinical site. And then signatures. Signatures are required on affiliation agreements because these agreements are considered legal documents. Only authorized personnel should affix their signatures to this. Alright, curriculum issues. EMS educators should establish a curriculum that is in compliance with the U.S. Department of Transportation education standards and federal and state laws, and that it adheres to accreditation standards. In student issues, we're going to talk about institutional relationships, enrollment and dismissal, background checks, discipline in the classroom, professional appearance, academic dishonesty, and bullying. EMS educators should become familiar with all the local, state, and federal regulations under which their program operates. This is vital that the educators have access to the appropriate support by administration and or legal counsel to avoid being placed in positions of potential liability. Institutional relationships. Positive student relationships is crucial in the success of a program and their graduates. Documents such as catalogs, handbooks, course syllabi, and advertising materials play an important role. All information should be correct, current, detailed, and readily available to the public. The publications that we're talking about would be like catalogs and student handbooks. In the catalogs, institutional data, academic requirements, enrollment and dismissal rules and regulations, and student support services should be applied in this. In student handbooks, things like attendance guidelines, curricula, uniform or dress code, and then the code of conduct for the students. Also, related printable documents, they will either be available online or should be available within the handbook or student handbook, or the policy and procedures at some point that the student has access to, was the ADA support, American Disabilities Act support, confidentiality of records, description of educational programs, financial assistance opportunities, non-discriminatory policies, refund policies, program cost, and veterans benefits. Challenges to printed documents. Catalogs, handbooks are perceived by students as legal documents that create a binding, inflexible obligation on the part of the institution. Printed documents are where many lawsuits originate. Educators should be careful not to violate students' constitutional rights when making program changes. Students' rights are simple. They have the freedom from discrimination, they have freedom of assembly, and they have a freedom of speech. Enrollment and dismissal. Recruitment ensures that unlawful discrimination does not occur. In the acceptance part of it, students have the right to know that what is accepted of them, not only in the general program but also in the clinicals as well. Dismissal. Student dismissal is similar to employee dismissal. So let's talk about one of these here a little bit, which is student dismissal. So student dismissal is similar to employee dismissal. Litigation may result if the EMS educator fails to do the following: regularly and objectively document the student behavior. And this means periodically. So like if you're teaching a semestered class, maybe twice, at a minimum, probably twice through the semester, evaluate the actual behavior, not only in the clinical environment, but also the cognitive environment and the psychomotor environment. Provide educational experiences, both academic and practical, directed towards success. Keep evidence of both positive and negative completed student work. Maintain fair and objective student evaluations. Communicate as though every word, written or spoken, would be broadcast in public. Treat all students the same and objectively. Maintain students' confidentiality before, during, and after the educational experience. Background checks. EMS education programs may require students to pass criminal background checks, including fingerprinting that screens for violent criminals and registered sex offenders, and review a tracking system for incidents of child abuse and neglect. Criminal convictions. Failure to disclose any felony conviction results in dismissal, and the policies on this need to be clearly defined. Illegal drug use. Explanation for positive tests possibly can be provided. Drug testing policies must also be clear. A student must not be compelled to disclose their medical condition unless it affects their ability to safely participate in the program. Also, policies on this need to be clear as well. Discipline in the classroom. One of the most common problems in addressing misconduct in the classroom, clinical and field setting, is discipline. Two primary pathways. There's academic discipline and then a disciplinary viewpoint or pathway. In the academic, this should include professional behavior expectations and evaluation, which is identified in the National EMS Education Standard. These should be evaluated every course, and if adequate, the student should not pass. And if inadequate, I apologize, the student should not pass. Disciplinary. This is another way, or another pathway to deal with the behavioral issues. Clear policies and procedures, though, should be defined on the disciplinary end of it. If you write a student up, have them do a corrective action plan for everything that you're writing them up on, and in their own handwriting is preferable. Professional appearance. Dress code policies may address the following: bodily piercing, fingernails, hairstyles including facial hair, jewelry, tattoos, uniforms, or any other related personal hygiene issues. Tattoos may need to be covered, piercings may need to be stud only, or clear retainers be placed in the holes of non-standard visible piercings. Again, this depends on the internal policy and procedure of the college that you're working for. Academic dishonesty. Academic dishonesty in the classroom is not a new concept. It is, however, on the rise with an increase in its use and capabilities in technology. Printed information in the handbook and syllabus should be clear and reinforced at the beginning of each course. Bullying. Educational institutions should have a strict policy that prohibits hazing and bullying of fellow students and coworkers. Consideration should be made for cyberbullying as well. Adopt a formal policy of hazing and bullying. Without this, the student may claim his First Amendment rights, which are freedom of speech. Grievance policies, and there should be two of them, not only for the educator, but also for the student, or vice versa, for the students and educators. As far as the students go, grievance policies should be made readily available to all students upon enrollment in the EMS educational program. Educator. EMS educators should also have published grievance policies related to their employment. This ends Part 2. If you have any questions, feel free to contact me. My name is Roy Smith, smithr@emsa.net, or 405-219-7613. Thank you.